Hello, good morning. Today we are going to discuss judicial reforms of Lord Cornwallis. In that, we are going to discuss Judicial Plan of 1787, Judicial Plan of 1790, and Judicial Plan of 1793. So let's discuss introduction. Lord Cornwallis succeeded Warren Hastings as the Governor General of India. He came to India in September 1786. His tenure as the Governor General was from 1786 to 1793. During this period, he introduced several important changes in the judicial system of India. The judicial system of Bengal, Bihar, and Orissa was reorganized on a completely new basis. Before accepting the appointment or the post of Governor General, Lord Cornwallis laid down certain conditions before the Crown. And these conditions were: number one, the office of Governor General and the Commander in Chief would be united under one person, that is, it should be united in the Governor General. The Governor General in Council will have veto power over the Council on all decisions made concerning administration and military. That means the Governor General in Council will have override over the council. His aims as Governor General were to simplify the complicated and expensive machinery of administration of justice and uproot corruption from the present judiciary and administration system, to tackle the problem of land revenue, then develop a proper system of administration of justice. So, Lord Cornwallis was Governor General from the year 1786 to 1793 and reformed the whole system of civil and criminal justice by a method of trial and error. He introduced changes in the judicial system in 3 years or in three installments: 17 Plan of 1787, Plan of 1790, and Judicial Plan of 1793. So these were known as Judicial Plan of 1787, 1790, and 1793 respectively. His most noted work was in the field of criminal judicature. So let's discuss the plan of 1787. The directors gave instructions to Lord Cornwallis to bring simplicity, economy, and purity in the judicial system. The existing separation of revenue and judicial functions was removed and both the functions were united. So let's discuss revenue reforms under this reorganization of districts. The existing districts were reorganized. The number of districts in Calcutta were reduced from 36 to 23. Then the appointment of collector. A collector was appointed in each district. He was an Englishman. Collector was responsible with two tasks. Number one, to collect revenue and to decide cases arising out of revenue matters. Collector of the district was also to act as the judge in the Mofissil Diwani Adalat of the district and decide civil cases. In other words, he, collector, also presided over the Mofissil Diwani Adalat district level civil code. That was the district level civil code as a judge. In Mofissil Diwani Adalat, he would decide civil cases and cases of zamindars. Appeal from this Mofissil Diwani Adalat lay to Sadar Diwani Adalat when matter when matter exceeds rupees 1000. The Sadar Diwani Adalat was the Governor General. Then there was a court of magistrate. In each district, the collector was invested with magisterial powers. He also presided over the magistrate court as a magistrate, where he was empowered to try and punish cases of petty crimes and offences up to rupees 200. The were to act magistrate were to act as justice of peace. The magistrate was to make monthly report to the Southern Nizamat Adalat. Offences having value of more than rupees 200 would be sent to the Southern Nizamat Adalat by this magistrate or by the magistrate court. Then establishment of Mal Adalats or establishment of revenue courts. Mal Adalats were revenue courts in each district which exclusively dealt with revenue matters. This court was presided by the collector who decided cases relating to revenue as he was in charge of revenue matters. Appeal from revenue court or appeal from the Mal Adalat lay to the Board of Revenue in Calcutta, and then from Board of Revenue appeal lay to the Governor General in Council. Establishment of registrar courts. An assistant officer of the collector was appointed who was known as the registrar. He was appointed in each district who presided over the registrar's court, which decided civil cases up to the value of rupees 200. But the decree passed by the registrar was not final until it was signed by the Mofissil Diwani Adalat, that is the collector. So this is the chart. Here the appeal from registrar court was laid to Mal Adalat. From Mal Adalat it was laid to Board of Revenue at Calcutta, and from Board of Revenue the appeal was allowed to Governor in Council. So here we have completed reforms of 1787. Let's discuss Judicial Plan of 1790. Before 1790, the entire criminal judicature was controlled by Muslim law officer. Was controlled by Muslim Nawab. By this plan, Lord Cornwallis introduced criminal reforms. He provided for reorganization of the criminal courts so as to provide for an effective criminal administration of justice. So let's discuss the reorganization of district into divisions. The districts were divided into 4 divisions. Earlier it was divided into 6 divisions, but now districts were divided into 4 divisions. Murshidabad, Calcutta, Dhaka and Patna. Dinajpur and Burudwan was 2 more divisions, but now the districts were divided into 4 divisions only. Mofissil Fauzdari courts were abolished. Mofissil Fauzdari courts were the district level criminal courts. They were abolished and they were replaced with the Court of Circuits. Establishment of Court of Circuits. A Court of Circuit was established at each of the four divisions. It was presided by two servants of the company and they were assisted by Muslim law officers, Qazi and Muftis. It was not a stationary court. Instead, it was a moving court which moved from district to district in their respective division to try criminal cases. It was required to move in its division for the disposal of cases. They were visited each district of their division twice annually. Then there was increase in the salaries. The salaries of all judges of all courts were fixed and increased to control corruption that was prevalent in the current system of justice. The officers engaged in the administration of justice were paid very insufficient salary to maintain their dignities earlier, and therefore they tempted to indulge in immoral practices such as accepting bribes. This resulted in miscarriage of justice for the robbers, dacoits, and other wealthy men. They could procure their release by bribing the judges, and therefore there was a fixed salary was given by the current system of justice. The collector was to make a report of the working of the courts. Then the collector to make a report of the working of the courts he was in charge of. That is the magistrate, Mal Adalat and Mufassil Diwani Adalat, and send it to the British Parliament of England biannually and annually. The post of Nawab was abolished. So under this plan, the post of Nawab was abolished. The post of Nawab, who used to preside over Sadr Nizamat Adalat, was abolished as he did not carry out criminal justice properly, and it was now presided by the Governor General in Council. Then the court fee was also introduced. The court fee was introduced to reduce the burden on courts. Court fees was only charged for pleaders or the lawyers of the court and for calling the witnesses of the case. Questionnaire sent to the magistrate. A questionnaire म्हणजे प्रश्नावली was sent to the magistrates asking for their opinions, that is asking for their feedback on the prevailing criminal judicial system. Let's discuss the defect of the Judicial Plan of 1790. The magistrate's opinion or feedback in the questionnaire sent to them revealed the evils of the criminal justice system. This made Cornwallis realize that certain vital changes were required in the system of criminal justice. Two important sources of these evils were: number one, defects in the constitution of the criminal courts, and number two, the gross defects in the Muslim law of crimes. So Cornwallis resolved to abolish the authority of Nawab over the criminal judicature and to transfer the administration of criminal justice from Muslim law officers to the company's legal servants. Then the next defect was the court of circuits were moving courts which were overburdened with cases, which caused them delay in moving from one district to another and could not visit some districts twice annually due to the delay. There was a lot of collection of power of Lot of collective power of administration and judiciary vested with the collector, which made him abuse his power. So, with this, I have completed Judicial Plan of 1787 and 1790. In the next video, I will discuss the judicial reforms of 1793. Thank you.